I had not intended to take any of my own bills ahead, but with the committee's indulgence, I have a witness on one who has a problem this afternoon in terms of scheduling. So I'm going to call House Bill 578, and I will yield the gavel to Vice Chairman Mumford. And I'd like to ask Mr. Floyd and Ms. Westmoreland to come around, please.
Ms. Westmoreland have the chair. This chair, rather.
Just as long as she has a chair. We don't put that in your job description.
Record reflect I didn't comment on you.
You had any dog fighting cases down?
You need to go visit him.
You want to tell them a little bit about that?
I will. Thank you, Mr. Chairman. I bring today House Bill 578. This is a rather technical change to a part of our death penalty law, and specifically that portion as it relates to the habeas corpus proceedings in a death penalty case. And essentially what it does, and because it's technical, I've asked District Attorney Floyd from Henry County to be here, and with all due respect to him, more importantly, Mary Beth Westmoreland from the Attorney General's office, who is a preeminent scholar and practitioner on this body of the law in Georgia, to kind of share with us the technical part. But what it, in effect, will do is put some time limits on the habeas, on some of the proceedings in the habeas corpus portion of these cases, to prevent these cases from languishing for inordinate periods of time. And with that, Mr. Chairman, if I could, just jump, whichever one of y'all want to go first, and then the other can chime in.
I'll start, Mr. Chairman. Let me say first what this is not. This is not an attempt to hurry through an important part of the appeals and death penalty cases. It is just as Chairman Ralston said, it is an attempt to solve a problem, that is, that when these cases reach the state habeas stage, that's where state habeas corpus petitions have been filed, there are some cases, more than a few, that have languished after the hearing, after all the discovery, after all the court proceedings, where judges have not ruled promptly. That is understandable. I'm not here criticizing judges. This is something else that is in addition to their normal duties. The judges that are assigned to these cases are assigned by the Council of Superior Court judges, and there are judges that are, by statute, from outside of the county or circuit in which the death penalty case came from. It is my understanding that many of these judges are sort of, I'll be willing to do this kind of thing, so it doesn't, while it can encompass all the judges in the state, it doesn't always. Be that as it may, the judges are assigned these cases. This bill also does not interfere with the investigative process of the attorney for the petitioner, that is, the person that has been sentenced to death. These are civil cases, and they have a right to discovery under the Civil Practice Act. They have a right to depose witnesses, and often do. The district attorney is not a party to these particular proceedings. We're often witnesses. I've been deposed many times in these type cases. Right to file interrogatories. This bill does not affect that at all. What it affects is once all that is done, and once a hearing is had before the judge, that there are time limits that are currently in the Uniform Superior Court rules that are being codified as it relates to the filing of what's referred to, and I'm on page 2, lines 1 through 6, the proposed findings of facts and conclusions of law. What happens is that the petitioner, a lawyer for the person sentenced to death, and the respondent, who is an attorney with the Attorney General's office, file their proposed findings of facts and conclusions of law and the judge uses those to compile his order, because he files more than just granted or denied. He must file a written finding of facts and conclusions of law that explain his or her ruling in the case, and then it, of course, goes up. And it sets timelines there of 30 days from the filing of the transcript. Starting on line 7 on page 2, section D, it was changed yesterday in subcommittee to the judge then has 120 days to rule in the case and to file that ruling. He may, in appropriate cases, and there will be some, if he is not able, he or she is not able to rule in the case, by that time he may file an extension by giving his or her reason. And that reason must be in writing and sent to and filed in the county where the death penalty case was tried and with the Georgia Supreme Court, and that would happen every 30 days until after that. That is simply an enforcement mechanism. It is, I would call it, a general persuasion to the judge to go on and get this thing ruled on. That essentially is what this bill does and doesn't do.
Mr. Chairman, and I'm Mary Beth Westmoreland. I'm Deputy Attorney General for the Criminal Justice Division in the Attorney General's Office. And just by way of a little bit of background, in 1995, this body passed a bill to deal with time limits in death penalty habeas corpus cases. No time limits were codified, but it was directed that the Superior Court Judges Council come up with time limits to put in the Superior Court rules. That was done in Rule 44. There's a lot of leeway given on the application of those time limits. This codifies two parts of those time limits and makes some modifications to it. As Mr. Floyd said, this does not impact the preparation of the case for the evidentiary hearing, the discovery process, or the filing of the petition itself. This impact comes when the evidentiary hearing is concluded, and it would set up a time for filing of the briefs or proposed findings of fact to run after the transcript of the proceeding gets filed. So the petitioner has a certain period of time, and then the respondent does. And then it gives the judge a set time frame for filing the final order in the case, the resolution. The question that was presented to me is this a problem? In some cases, yes, it is. And I'm with Mr. Floyd. I'm not picking at any judge. Judges have busy schedules. We have cases currently that have been waiting just a few months for a final order. We have cases that have been waiting several years for a final order. We have currently one over 4 years. We still don't have a final order in it. I can't explain that to a victim's family, and there's no way for anybody to go in and get any reason for that at this point in time, and that's the reporting mechanism. We're fully aware of the fact that the judges have things that come up. A judge may have his own death penalty trial, and that's all that the report would have to say. I'm involved in a death penalty trial. I can't get to it right now. And that's the purpose of it, is to give the parties and the public some idea of what's happening. Questions?
Question. Is there any discussion before any amendments were reached? And there are some other people that want to speak on this. I do want to ask Ms. Westmoreland a question. As this is written, it's every 30 days. Was there some particular reason why 30 days was selected?
Mainly because the time limits of the rules tend to be in 30-day increments. They're 60 days, 90 days, but that's one of.
And the same with the 120-day initial requirement.
For the order, the initial, because the bill as originally proposed had 90 days, and the judges
basically we're going
asked.
from a situation where the court is not under any obligation to make this decision at any time, to where we're putting a restriction on them. They must make it in a particular time.
Currently, the Uniform Superior Court rules provide for the judges to make a decision in 90 days. That's by rule that the judges develop. It's not codified anywhere in the statute. This puts a codification on it, and actually, as the bill stands today, it increases it to 120 from the current 90.
there are some people to speak on this. Anybody else have any questions about this? Y'all can clear off mine. Thomas H. Dunn.
Mr. Chairman, members of the committee, I spoke briefly yesterday at the subcommittee. My name is Thomas Dunn. I am the director of the Georgia Resource Center. The Georgia Resource Center is a not-for-profit law firm that was established in 1988 with the combined efforts of the Georgia Bar, the state courts, and the federal courts to ensure that men and women sentenced to death in Georgia have adequate representation during the state habeas and federal habeas process. We essentially represent everyone on death row, or do that through either direct representation by the small staff that I have, or with the help of pro bono volunteer counsel throughout Georgia and the United States. I have two preliminary observations that I want to make, and I'm going to clarify a little of what I said yesterday after talking with Representative Collins, because I think I learned a lot from what he said. The first is this: if you go to Attorney General Baker's website today and click on it, he's going to list as one of his 5 top accomplishments is that death penalty cases go through the post-conviction process faster than they ever have in the history of Georgia. And I totally agree with that. They do. And I think that Rule 44 and some changes in the federal law have ensured that that happened. The second observation is, although it's going through quicker than they've ever gone through before, I think the system works. The Columbia Law School did a study in 1997 which looked at all cases throughout the country and reversal rates from reinstatement of the death penalty after Furman to January 1st, 1996, and found an 80% reversal rate in Georgia cases. Since that study, from January 1st, 1996 to the present day, 19 men have been executed after the courts and the parole board have found that their convictions and death sentence were constitutionally obtained and carried out. In addition to those 19 executed, 22 have obtained relief either from their death sentence or their death sentence and conviction because their convictions were unconstitutionally obtained. To me, that indicates not a criticism of our death penalty system, but a really indication that it works and that the system is working well. I think the state habeas process, as Mr. Floyd said, is an important part of ensuring that our death penalty system works properly and works well. As Representative Collins pointed out yesterday, this legislature in the last couple of years has done quite a bit more to make sure the cases that are getting reversed now in state habeas in the future aren't gonna, with the implementation of a statewide public defender office and the capital defender office specifically. I think my workload will decrease because I think the work will be done properly and well at the beginning, and I think that's an important point to make. There are still right now as of today, I think it's 114 cases that weren't prosecuted through that system, and I think there are problems with some of them. I know there's been some discussions off the record about changing the 60-day requirement for the briefs, and that would be on page 1, line 26, to 90 days, and that was proposed yesterday by Sandy Michaels of the Georgia Association of Criminal Defense Attorneys. It's my understanding that Ms. Westmoreland and the District Attorney Floyd did not have they're not taking a position on that, and I would ask that it be extended to 90. I think that would, in one way, prevent the judge from having to give an extension. I think that's usually, it probably briefs are filed at around the 90-day period. My bigger concern is that the problem here is a handful of judges who have not ruled quickly. From my experience, and I've been at the Georgia Resource Center 8 years this time, and in the early 90s I was here for almost 4 years, is that most judges decide these cases fairly, conscientiously, and work really hard at doing it in a timely manner. There are a handful of judges who haven't done that, and I think my concern is that this bill puts an artificial timeline on judges who do this voluntarily. This is done in addition to their normal heavy caseload. They typically have to travel to Butts County for a week or so to hear witnesses. Habeas corpus records literally have thousands of pages of paperwork. Paperwork that, despite even having a 5 or 7 or 8 day hearing, many of which are not even mentioned in court and not addressed until counsel for petitioner or counsel from Ms. Westmoreland's office talk about them in a post-hearing brief. I'm just concerned that 120 days puts an undue pressure on judges that ultimately is going to hurt the effectiveness of the system, and let me explain it this way. Congress in 1996 passed the Anti-Terrorism and Effective Death Penalty Act. What that act did was to take federal court jurisdiction and say, no longer are you going to be the sole arbitrators of what's constitutional in terms of death penalty jurisprudence, but we're going to give deference to state courts if state courts do it properly. I actually believe that's a good law. I believe that the review ought to occur in state courts, and I believe, as I just testified to, that for the most part it really does work here in Georgia. Under the ADPA, the federal courts will not disturb a capital conviction or a death sentence if they will give deference to rulings if there are adequate findings of fact and conclusions of law. And that's what we're talking about in this bill, is actually writing those. Not necessarily the result, but how it's justified. I'm concerned that putting these time limits will require judges with their busy schedules, one, to not volunteer to do this, or two, to be forced to accept proposed findings of fact by either counsel for the petitioner or counsel from Ms. Westmoreland's office. That, under the ADPA, is going to cause problems. Those kinds of findings of facts are not looked upon with great favor in the federal courts. In fact, in 2000, the 11th Circuit Court of Appeals held a judicial conference in which defense counsel, prosecutors, Ms. Westmoreland wasn't there, but Senior Attorney General Susan Boleyn was there, in which the judges very candidly said to the litigators in the field, myself, Ms. Boleyn, that proposed findings of fact are looked at disfavorably, that they want judges who do their own writing, their own thinking. And these orders are not a 5-6 page order. These orders typically average 100 to 200 pages. These are very complicated cases. I think probably the most complicated area of criminal law that there is. That is my concern, that this judicial time constraint, one, only addresses what's a problem with a handful of judges, which could be taken care of through a mandamus, and I would ask that the Vice Chair and Chairman consider that.
Is there a question? Yes.
I don't have any way of verifying what either preacher or favor would say or what your opponent says, but during the last election cycle, one of the attacks that was made against the Attorney General was that under his watch, the average death penalty process now averages 15 years. It was up 50% from the 10-year average under Mike Bauer. So all I'm suggesting to you is there is some data out there, I assume somewhere, that suggests that there is a lengthy process out there rather than it speeding up. That whether it's going faster or slower, if there's any credibility that it's 10 years, that's taking a long time for what those who face the death penalty would say justice and correct retribution to be.
Yeah, I could respond to that. I think probably that the average has gone up, in large part because the cases are taking longer in federal court now because of litigation of the Anti-Terrorism and Effective Death Penalty Act. That really added some significant changes to an area of the law which had been pretty stable for 20 years, and that clearly has slowed down the process in federal courts. Here in Georgia, there is no question that these cases are moving quicker than they've ever moved. In 1995, I did 2 evidentiary hearings. This year, I probably will do 14. That is a big increase. Big increase.
Sure, I'm sorry.
Sure. No, I'm finished.
Do you know by any chance what the average time is for a death penalty case from the time of the first appeal to the imposition of the death sentence, if in fact that penalty sentence is
That is carried out? Yeah, I don't know that. No.
If you hate to use the word, Mr. Lord said, yes, do you have any speculation at that point?
I think the average is probably 10 to 12 years. And that's here in Georgia, and I think that's pretty consistent throughout the country.
Thank you. Thank you, Mr. Chairman.
I have a question. Do most of the judges that come to do these hearings, do they have the benefit of a law clerk to assist them in preparing these matters?
There is one law clerk that is provided through the Superior Court Counsel that just does habeas cases, and they do have the assistance
So
of
they
that
meet with
clerk.
that clerk and discuss the issues?
My understanding is it's their choice. Some of them do use the assistance of the Superior Court clerk, some of them don't. To give you an example, there's one clerk, there's currently 54 cases in Butts County right now, so that's a pretty heavy caseload for one clerk.
Another question, Mr. Chairman. Chairman Knox.
This is exactly my point.
Yes, sir.
I've read somewhere recently that we have had in Georgia, and I think it was since the law changed, that there were 6 people released from death row. I've got what the circumstances were. In addition, there were 5 people released or otherwise condemned to death or released based on clemency. Is that still going to make any bell?
I just said since January 1 of 96, 22 men have gotten relief from their death sentences. I do know in Georgia, yes. Of those, 11 have already been back through the process and received sentences less than death. 2 of them are juveniles. They're still in litigation, so they can't be sentenced to death. And the other 9 are still pending. I believe that there have been 6 people or men sentenced to death post Greg v. Georgia who literally have walked out of prison after serving a life sentence. Or there has been at least one exoneration. The others, I believe, were let out basically on parole. One exoneration post Greg of someone actually on death row.
Get out on parole on death row.
It's actually happened. I don't know how it happens. Very old cases.
All right, any other questions for this gentleman? Thank you very much for coming.
Thank you, Mr. Vice Chair.
William Montrose. Did I pronounce your name correctly?
My mother and father pronounce it differently, so that's fine.
How do you pronounce it?
Montrose.
Montrose.
Chairman, Vice Chairman, members of this committee, my name is William Montrose. I'm a death penalty litigator at the Southern Center for Human Rights, which is here in Atlanta, Georgia. I'm appearing before you today to talk about a few points that Mr. Dunn has graciously allowed me to mention. I want to emphasize first, and Mr. Dunn did this, I think, very effectively in terms of how much work the judges have to do in order to prepare these petitions. They are extraordinarily difficult. The issues are complicated. Their final work product is lengthy. Chairman Knox, I believe, mentioned a question about exonerations. What happens at the post-conviction process is perhaps, particularly on the state level, the most important time for review of these death penalty cases. On direct appeal, you are limited to the record. You are not making challenges to the effectiveness of the counsel. You're not making challenges to the effectiveness of the mitigation presentation that was done at the penalty phase of the trial. You're not making challenges to juror misconduct or judicial misconduct. You're not making challenges to Brady information. All this stuff becomes available, apparent, discoverable during the process of the post-conviction process. Now, I understand this bill does not affect the investigations, and it does not affect the ability of the attorneys to go out and get this information. But at the same time, we are going forward to these judges with binders this big to them with documents that we have found. Now, this is a Georgia case. 20 of these binders were submitted to the judge by the state. Okay, we submitted another 15. The judge has to go through all these records. They're not mentioned necessarily at the hearing. They can be simply briefed later on. The judge also has to go through the trial record, which can take weeks of testimony, besides the hearing record. These cases take a ton of work. I understand the Attorney General's office testifying on behalf of this bill. I would speculate to this committee that if a line AG came in who was handling these cases, and I have 10 of them myself, and had a number of these cases, would probably say, you know, I really don't think I can get my briefs in 90 days. I'm going to be asking for extensions. On the line, on the trenches, these cases take a very long time. One other additional point. Mr. Dunn mentioned that the judges volunteer for this. It's a service that they provide. They're not asked to do it. They do not have to do it. In addition, Mr. Dunn's office cannot handle all the post-conviction cases that take place in Georgia. There are conflicts. Okay, he's not allowed to represent clients who have conflicted positions. There are simply a large number of cases where, by necessity, his office, as he indicated, goes out and seeks pro bono attorneys to come and take these post-conviction cases. And you look for them in Georgia and you look for them nationwide. And sometimes you literally have to go begging. The money is not there. The attorneys will not get paid a lot of money. It literally is volunteer work. But we're not the only state asking for volunteer attorneys around the country. Alabama is, okay, and Texas is, and Mississippi is. And it seems to me that when we are fighting for attorneys to come in and handle our post-conviction cases, that it's unlikely that a volunteer attorney will say, I am going to abandon my practice so I can come in and write a post-hearing brief in 90 days. I fear that this bill threatens to do something that I never thought would happen, that attorneys would rather do post-conviction work in Alabama than they would in Georgia. And I'm urging this committee to consider the long-term effects that this bill will have, not only in terms of judicial practice and the quality of opinions that are being issued by the judges, but in terms of attracting lawyers and volunteers who are willing to do these cases and who are willing to do them properly. Thank you.
Thank you very much. Any questions? All right, thank you. Were there any proposed amendments? Yes, ma'am.
I just have a simple Scrivener's amendment on page 1, line 26. At the end of the sentence, it says, if directed, the court, comma, shall. That comma is misplaced. It should be stricken between court and shall, and should instead be inserted between directed and the. So that phrase would read, if directed, comma, the court shall.
Are you channeling Tommy Bordeaux over there?
Having never met him, I hope not. I'm just I'm just deeply anal retentive. So.
Second. All right. I'm sure that the author of the bill is going to accept that rendition. Is that correct? Absolutely. All right. Are there any other amendments to this piece of legislation?
Mr. Chairman,
Yes.
I would move on line 26 on page 1 for striking 60, put in 90.
All right.
And on page 2, line 3, to be fair, strike 30, put in 60.
All right. That amendment has been made. Is there any objection from anyone on the committee? Hearing none, that amendment is adopted. All right. Are there any other amendments to be made to this bill? If not, I recognize Chairman Knox for a motion.
Chairman, I move to pass House Bill, substitute House Bill 578, LC 2928,
believe that since those motions were made, I think both of them have been accepted by the author and were unobjected to, that amendment has been made. There's a second to the amendment to the motion to pass. All those in favor, please say aye or raise your right hand. All those opposed? Opposed? All right. That concludes consideration.
Thank you, Mr. Vice Chairman. I have a number of inquiries during the break about taking lunch. I think we are going to do that. It is now 12:30. I think this is as good a time as any. When we come back, my intention is to take up first House Bill 394. We will stand in recess until, let's say, 1:45.
What we have
Does
done.
that mean that people that are, excuse me, I don't mean to interrupt you.
What we've presently done, or what we've been doing since 1990, is that every subsequent conviction, if it's a misdemeanor or felony, just for GCIC purposes, reflects a conviction, so that nobody else is supposed to pick that up for the future and allow first offender to be applied again.
Well, does that mean that people who actually got first offender are being shown as being convicted so that they can't get jobs, or?
As you know, the public can have access to certain GCIC records.
When you go to a job and you waive the right to have it,
that can be
give the
run.
employer an opportunity to go run it.
But I think there are certain databases that still show the conviction, even if there's a first offender entry.
Right, but you would agree that theoretically, since the first offender is designed to not cause any civil or criminal penalty, that the civil penalty of having a record shown to an employer that's not supposed to be there would not be a good idea, right?
No, what I'm suggesting to you is not an issue of either one of those, that fact in any way. The offender, under your proposed legislation, has the opportunity to correct his record and can show that to his employer as well as the GCIC record. If the employer hypothetically presents a GCIC record that shows a conviction and the offender says, no, I was adjudicated that, he has the opportunity to produce that record to the employer. He still has that opportunity. And don't forget, for the most part, that these this first offender status or first offender provision is not binding on any other jurisdictions besides ours, and in many jurisdictions it is not recognized, and I don't believe it's recognized particularly in federal court. For the most part, it's an anomaly or an unusual set of circumstances for us here in Georgia. We're not asking you to modify the entire bill, just simply that provision dealing with the GCIC record. Again, going back to your question, the offender has the opportunity to correct that record with the employer whenever he wishes to.
Yeah, but by the time he's corrected it with the employer, he's lost the job opportunity.
That may be the case, but by the time he's also the 10,800 who have violated the intent of the first offender by obtaining it a second time, they've already, the horse is out the barn then.
That take care of you for that.
I guess so.
Representative Bearden.
Mr. Moss, this is something Chairman Knox was talking about. If you put back in subsection D on page 5,
Mm-hmm.
the part that's now showing the new language, showing treatment of first offenders can be modified only when a court jurisdictionaries and adjudication of guilt.
Yes.
Does that need to be stricken and the rest stay, or does that whole new language?
That section, the record, I think from the word record on down below is probably okay.
So the royal would need to be stricken. It's just that first.
You would
line 10, line 11 to stop at guilt.
You would if you followed our recommendation, you would in fact go back and not modify the original language. You would not need the this section, the proposed change, until the word record appears.
Representative Levitas.
I'm remembering correctly that once you use first offender, whether you successfully complete it or not, that's it.
That's supposed to be the case, yeah.
And so I guess what I'm trying to, and I want to help if I can, but I'm just trying to figure out what the problem is here, because if, whether or not it shows a completion, if they've invoked the First Offender Act and that's reflected, they're not going to be able to gain anything by trying to, am I missing something? How would they be able to use first offender status twice if the record showed that they're under sentence at some point?
Well, the offenders on, as I indicated by example, 10,800 separate occasions, once being adjudicated as a first offender over 10,800 times in that 15-year period, persons have come back on second or subsequent offenses and have gotten a second or third opportunity to be called first offenders. Just what happens is, you know, is you'd have to file a motion to correct the sentence if that were the case. If that had happened in DeKalb County and you hadn't caught the record, somebody come in and had been pled first offender where they were not entitled to it, then the way you can correct that is go back and re-sentence.
May I have a follow-up, Mr. Chairman?
Sure.
I guess, and I understand that I had to do that in DeKalb sometimes, but that was in instances where we didn't have any indication, even from looking at GCIC, that there was a sentence under the First Offender Act. And so I guess what I'm trying to get at is, this is applying, is it not, in cases where the GCIC is reflecting first offender, it's just not showing any change in status, where in fact a change in status may, let's assume, may be warranted. Is that right?
Well, let me answer. Hopefully, I can answer your question this way. Currently, once a first offender conviction is entered, it's shown on the record. If there's a subsequent offense, just for GCIC purposes, they go back and show that as a conviction, not as a first offender treatment, or not as an adjudication of guilt, innocence rather. That's just for GCIC purposes.
And what purpose ultimately does that serve for you as a prosecutor or as a sentencing?
Well, first of all, in behalf of the GBI, they'll have a tremendous problem in changing their software program to accommodate, to change a program that was modified in 1990. For us as prosecutors, it prevents those circumstances, again, where somebody messes up and they get first offender on a second or subsequent occasion, just to prevent having to go back. And there may well be times where people enter as first offenders and it's not corrected.
And Mr. Chairman, if I can maybe ask someone on the committee or esteemed counsel, and I have the greatest respect for our witness here, I'm just not getting how that, if the first offender status is reflected in GCIC, how that fact, whether there shows a subsequent conviction or not, would it allow somebody, just based on that, to obtain another first offender plea?
By entering first offender without looking at the record, frankly.
Okay, but that wouldn't, again, that doesn't have anything to do with this particular provision, right?
No. Your provision, the bill, as the most part, provides a mechanism where an offender actually gets his record corrected. The only objection is with GCIC.
Thank you.
Let me remind members of the committee, I hope he doesn't mind me doing this, but John Bankhead of the GBI is with us today and may be able to weigh in on this discussion. Not that Mr. Moss needs any help, but he is doing an excellent job.
One thing, the way we operate is through fingerprints too, and that's confirming that person's identity. And it's done by a software program where these fingerprints are submitted electronically. So when the software program picks up that this person by fingerprint has a previous conviction, a previous first offender, basically what he said is true, nobody checked. And so it automatically upgrades. Now if there's a judge who wants, for whatever reason, to maintain this person under the first offender status, then we receive a court order, a judge's order from that judge. We do this routinely, and we go back and correct it to make sure it stays a first offender. So that issue, we handle that as well on the court. This, you just don't have any oversight. As he says, there's 10,000 that are abusing the system, in our opinion. First offender status should go to those people, in our opinion, that have only committed one crime, not likely to commit another crime. When they're allowed to do it more than once, in our opinion, it's abusing the system. And this is the only oversight that I know about to prevent that abuse.
Representative Abrams.
I have a couple of clarifying questions. You've used the number 10,800 as the number of occasions. How many of those are, or do you know how many of those actually reflect one offender and multiple acts by a single offender? Do you know what that number is?
I don't think it's the case. I think it's on second or subsequent opportunities, or second or subsequent entries of a first offender sentence, not within the one conviction with multiple offenses.
So, but what I'm saying is it John who keeps getting arrested in different jurisdictions, or is it John, Peter, and Paul? So do you have 5 different people, or do you have one person who's just gaming the system?
One.
Okay, and my second question is, using your underlying number, which is more than 200,000, it strikes me that that's about 5% of the entire population that's captured by the GCIC mechanism, correct?
Using those figures, the 200,000, 220,000
So
actual dispositions, and about 10,800 fraudulent attempts to obtain that same offense
So
status twice.
about a 5% fraud rate. It would strike me that there's no. The third question is there's no notice to a first offender that their record is incorrect until they've not been given a job by an employer, essentially.
No, ma'am. Actually, the onus get easily on the offender himself in order to correct his record. What the court's simply saying in the first offender sentence is that if you successfully complete your period of probation or sentence, but split sentence, then you will be found not guilty. The record still stands as it is until somebody changes that record. We're not suggesting that the record, that this bill should be killed in forcing people to change the record where it should be changed, just in the GCIC database.
I would say that, like my able colleague, Mr. Levitas, my plain reading of this doesn't seem to show. I can't figure out what the problem is. I mean, what it seems to say, the plain language of the recommended amendment says that if you've been shown as a first offender, the only opportunity for GCIC to report that information as a conviction is if there is an adjudication of guilt entered by a court. It then says that those records are restricted to certain personnel and they're not available to prospective employers or to any other person demonstrating that there is any adjudication of guilt unless an adjudication of guilt has been entered into by the court. It strikes me that the purpose of a first offender program is to allow persons who have made a mistake, have broken the law, to correct that, and then to be given the opportunity to continue as viable citizens. And that the way this is drafted, I fail to see any area. I did listen both in here and then there to your explanation, but I still can't discern what harm this language does. And if there is harm, it seems to me that according to your numbers, the harm is a 5% harm, which means that, which is to me an acceptable number when you're talking about the ability of a person to attain a livelihood and to maintain their status as a productive member of society, as opposed to, because they are unable to secure employment, possibly becoming that recidivist that you're afraid of creating. So I have a very difficult time understanding why this amendment is not acceptable.
Again, it's the cost in creating the system, in reworking the system, and the fact that two factors. One, it's up to the individual to modify his or her record. Nobody stops that. It's still up to her to do that.
Can I clarify one thing? The cost that you speak of, is that the $20,000 initial cost? So for $20,000, we could fix a problem that could cost a person their livelihood. I mean, I guess, again, for me, it's a 5% $20,000 issue versus the number of people who could benefit fully from the public policy stance that the state has taken to provide a first offender status and therefore provide the opportunity for these persons to reenter society and to become and maintain their productive, gainful employment. And so
that cost plus the number of parties who are abusing, over 10,000 who continue to abuse.
Which is the 5% number I was referencing.
Yes.
Okay, thank you.
Vice Chairman Mumford, I think, was next, and then Chairman Knox.
I have a question for Mr. Bankhead. Does the current system not discriminate between people who have completed their sentences under first offender?
Yeah, it's only applies to those still under probation.
How? I mean, you'd have to have a factor in your program for how long their sentence was, which I don't think that you do. And isn't the problem that's going on here is that you got people who might have a first offender sentence for 5 years, and 10 years later they get another offense, and then you're wiping out their first offender treatment on the first one due to an arrest on a second offense?
I'm not aware of that.
Okay. So I'm just wrong about that.
I don't know. I can't tell you.
Okay. Well, Can you kind of walk us through how a first offender gets treated by the computer and how it gets undone?
Mr. Bankhead, you want the microphone?
He can talk loud enough.
I can talk about it. It's all done by software, as I explained before.
Right.
It's a software program.
Right.
It's all based on what is submitted by the courts regarding what action they took. And if the person is under first offender, the computer notes that. If he gets a second conviction during that probationary period, his first offender status is changed to reflect a conviction. If he gets
How does it know what the probationary? I mean, it knows what the probationary period is.
Probationary period is.
Okay.
You got to know when to take him out. I mean,
Right.
Part of the legislation we had to deal with on the sex offender registry. And that comes from the clerk's office.
Can I follow up with one other question?
Yes.
What would it cost to upgrade the system to deal with what this bill requests?
Between 15 and 20,000.
And aren't there are routine upgrades that go on a regular basis, right?
Well, there's a major upgrade going on now, whereas right now we have to manage it ourselves when the judge's court order comes in about split sentences or about changing a first offender status back to that. But with the upgrade, we'll be able to do that automatically within the program without an individual having to manage the system or manipulate the system or change it.
Chairman Knox.
Is there an issue here with usurping the judge's authority in this case where, well, I'm getting at, because the judge gets, now I think this is what I was trying, I see you shaking your head no, but the thing is that if the judge gets to decide, even on a misdemeanor offense, for instance, somebody comes in, made a U-turn, and they were on first offender status, the judge gets to decide whether or not to revoke their first offender status, right?
Can on traffic offense, any violations of the law, but it would not affect the issues of GCIC because then that U-turn's not going to get recorded.
Okay, well, that's a bad example. A misdemeanor, then, that would be recorded on GCIC, whatever that would be.
Domestic violence.
All right, domestic violence. The judge gets to decide whether or not he's going to revoke first offender status in that case. Well, I think I hear you saying, correct me if I'm wrong, I think I hear you saying that when y'all now, if the person asks for first offender status on the domestic violence, for instance, let's assume that they didn't even know they were on first offender, forgot they were on first offender, thought they could get another first offender. They didn't say anything. They're just standing there dummy-like, and the lawyer's saying, first offender judge, and the DA saying, okay. And nobody checks it. You get it. And y'all, I think I hear you saying is that when that goes to GCIC automatically knocks off the first offender status so that they've now got a record of a conviction in that case.
Just for the computer.
Just for the computer, I understand. But I think the point somebody else was making is, I think Representative Abrams, was that the employer now goes and picks that up and says, oh, I'm sorry, you've got a felony conviction, I can't hire you. Whereas if that hadn't been done, just because the application was inaccurate, then they may not have been knocked out of the job because it's a misdemeanor family violence. Correct?
Well, you may be correct in that. The only response, again, is up to the offender to correct the record. And that can be done.
I understand that, but my point is that if the judge hasn't seen fit to revoke their first offender status, then should we give that authority to GCIC that's going to make this record available to employers? Should we give that authority to GCIC to say, as just because of our record keeping ability and system, we're going to record it as though the judge had revoked their first offender status when in fact it hadn't been revoked yet?
That's been the status since 1990.
And that's what you want to stay with. Okay. And I think, would you agree that this is going to say that we can't do that? You got to fix
Well, that changes it, modifies it.
Okay. I just want to be sure I understood it.
Further questions?
Thank you.
Promise. Secretary Beard.
Mr. Moss, we really don't have a problem with anything until we get to page 5 of that one section.
Yes, that's correct.
If that part changed, I don't know if I want to say you're all fine still, but that would help a lot.
Yes.
For your area, correct?
Yes.
Thank you.
That's our only concern.
Further questions, further discussion?
Excused.
Thank you very much, Mr. Moss.
Thank you.
I think you're off the hot seat now. Well, maybe not.
It's a motion.
Representative Levitas is recognized for a motion, the content of which I know nothing about.
And perhaps neither does the author, as we demonstrated earlier today. I believe this would be in the nature of a friendly amendment, Mr. Chairman. This would go on line 11 after the period following guilt. The purpose of the amendment...
What page?
I'm sorry, page 5, line 11, after the word guilt. And again, the intent of the amendment is to make clear here that what we're talking about is that the court having jurisdiction over the first offender has entered an adjudication of guilt in that case. As I think we talked about in discussion, the subsequent conviction doesn't necessarily render, the subsequent act doesn't necessarily render a first offender into the status of adjudicated guilty. So the amendment would just add the language for the offense for which the offender has been sentenced as a first offender. And so the full sentence would now read, the record beginning on line 3, the records of the Georgia Crime Information Center showing treatment as a first offender shall be modified only when a court of competent jurisdiction enters an adjudication of guilt for the offense for which the offender has been sentenced as a first offender.
I don't have any objection to that amendment.
You don't want
Although
that
this
to-
isn't my bill, I guess I'm carrying it, so
Might not be a bad idea to not object.
I don't object to it.
Are you putting that in the form of a motion?
That would be a motion.
I would accept that as a friendly amendment.
Is there objection? Well, it's not anyway, second.
No, there's no second.
Have a move and a second. It's accepted by the pinch-hitting author. Is there any objection to the Levitas amendment? Hearing none, it's adopted. Representative Bearden.
Make a motion for amendment. I may destroy his amendment, but on 5, I'm sorry, page 5, line 3, putting back in its entirety, subsection B, at the period on line 9 after convictions, striking the first sentence showing treatment as a first offender shall be modified only when a court, the competent jurisdiction enters an adjudication of guilt. Strike that, and I hope that will keep the integrity of the author and also make the DAs more comfortable, because I'm a unifier and like to bring everyone together on this.
Wait a minute, you're what?
I thought that might slip by, but it didn't, so. And that would strike, Representative Levetta says added language that he just put on there. And all subsection B.
Point of strike.
This appeared.
Hang on just a minute. Jill, did you get all that?
I did.
Okay. Representative, wait a minute.
As I understand it.
Wait, hold just a moment. You made a motion.
Yes, sir.
Was there a second? Okay. Discussion. Representative Levitas.
This is to the author of the bill, and maybe I missed it in his move when we moved for it. And I assume that his motion is to strike all of those sentences plus the language just adopted under the Levitas amendment. Is that correct?
Under this, I would, and if this fails, of course, yours is still there.
And I would have a substitute motion, Mr. Chairman, at the appropriate time.
Recognize you for that now.
I would, and this really is by nature of a friendly amendment to his. I realize that I've used an inartful term. I don't think the correct term is first offender. I think it's first offender probationer. So to the amendment, I would.
They may not be on.
No, he may not be a probation.
Okay, so it's a first offender is the correct term that I would.
You can go to prison and be a first offender.
Okay. Then I withdraw my amendment.
Okay. So we stand with the motion to adopt the Bearden amendment. Any discussion? Representative Abrams.
Well, Well, I appreciate the harmony intent of Mr. Bearden. I'm concerned that we place back in the hands of GCIC the ability to independently show conviction in lieu of treatment, to show conviction. I believe the point of this is to require the court to determine that there's an adjudication of guilt and to have that entered by the court and not by GCIC. I'm not compelled by the number 10,800 because assuming that's a repeat of one person, and let's assume it's the majority of them, that's still less than 5%. It's closer to 4% of all the offenders, and it's a $20,000 issue, which could or could not determine the economic stability of an entire family. I'm deeply concerned about the fact that while I do respect GCIC and GBI, I do believe that it's important for the integrity of the first offender program for the court to make the determination that the first offender status has been violated and would instead support certainly Mr. Levitas' earlier amendment, but would be very staunchly opposed to this amendment.
Representative Beard.
Although 5% sounds slow because we got such a high number, the number of 10,000, over 10,000, attempted fraud seems very high. And that's the reason why I think I want to move forward with this, because I think the DA feel and GBI feel this bring it back together to where it needs to be, and that's where the amendment is. I just have to be supporting the amendment.
If I can make one clarification.
Representative Abrams.
The 10,800 number is it's about 4%, 4.1% over 15 years. So we're not talking about in a year's time 10,000 people who are misusing the system. You're talking over the course of 15 years, fewer than 5% have misused this program, have engaged in an act of fraud. And the willingness to harm the other 94, 96% simply because of bad actors and a very limited number over the period of almost a decade and a half is just, I think, and when the issue can be corrected for $20,000, I think is the other part that we cannot lose in this. And so I would, again, with all due respect to Mr. Bearden, strongly urge that we not accept the amendment.
Vice Chairman Humphrey.
With all respect to Mr. Moss and his statistics, also, I was in the court system back in 1990, and I think that any statistical figures that you're using that are including 15 and 16-year-olds, 17-year-old statistics at this point have to be somewhat suspect, because in 1990 there were many courts that were not computerized. Now, today, almost every court is computerized. It's much easier to get a GCIC printout in court. Back in the old days, you might not have one in 1990. Today, everybody's got one. Your 3-year-old can get one. I would be a lot more interested in seeing some more recent statistics, because I think that the problem of cheaters on the system is probably substantially reduced more recently than it was in 1990.
Further discussion? Further discussion. We're on the Bearden amendment.
So you can't vote on this.
Further discussion. Hearing none, all in favor of adoption of the Bearden amendment, please indicate by raising your right hand.
We got to get it. He's contagious.
All opposed. I don't think I need to break the tie with this.
Thank goodness.
The Bearden amendment fails. What's the pleasure of the committee? We have a motion by Representative Abrams that it do pass. Is there a second? As amended, right. We have a second. All right, we have a motion that House Bill 395 by sub as amended be given a due pass recommendation. Is there discussion on the motion? Is there discussion? Hearing none, all in favor, please indicate by raising your right hands. Thank you. All opposed? It has passed. To where, I do not know.
That was $3.95.
Just for those of you who may have an interest in HB 226, we're going to hold that one for next week's meeting. That's I need to consult with Chairman Willard on that. So that one will come off today's agenda.
You carry this one too. I'm supposed to.
Where is?
I'm right.
You ready?
You want me to try and do 4:15?
Could
we? I would suggest that we take an afternoon break for about 10 minutes if we could.
Okay, let's take a break. We'll be in recess for 10 minutes. HB 653 in Subcommittee 2. It's a good bill, I hear. It's a good bill. My bill. That's the only subcommittee assignment today. We're probably not going to get you a schedule on next week until tomorrow morning, and that's due not to our not knowing what we're doing, although I guess we might be guilty of that to some extent. But we're trying to coordinate with the other Judiciary Committee about meeting times next week. What I understand may happen is that the subcommittees for this committee will be meeting sometime on Monday, possibly into Tuesday morning. So we'll probably convene this. We will convene this committee, full committee, on Tuesday. I'm just not sure yet whether we're going to start in the morning or the afternoon. And given some of the work that we have yet to do, there is a very fair likelihood that that could spill over into Wednesday. It's my intention that when we leave, though, on Wednesday, that the work on House bills for this session will be completed, and then you'll get to buy tickets for the Rules Committee meetings the last couple of days. So, any questions about the schedule? That's not very specific, but that's as good as I can get it for you, and we'll try to get that out tomorrow. And I understand the Setzler Special Study Committee, or the Special Subcommittee, is meeting, what, Thursday morning?
Tomorrow morning, 8:30.
Tomorrow, yeah, okay, that's Thursday. And that's on House Bill 276. Okay. Do you have a question? Representative Collins.
Is there an approximate time to start subcommittees on Monday? Or has that been even discussed? I don't know way ahead of myself.
What time?
Chairman said 1:30.
Chairman Mumford?
1:30.
I think they're both going to start at 1:30. Okay. Unless I don't know yet what time full committee's going to meet. That's going to depend on some discussions. Any questions? If not, I'm going to call House Bill 586, and I would ask Ms. Haskins and Mr. Kimbrough if they would come around, and I will yield the gavel to Vice Chairman Mumford. Yeah, I'll speak briefly. Thank you, Mr. Chairman, members of the committee. This is a bill that I introduced along with Representative Fleming, and I have worked with both the Public Defender Standards Council and the Association of County Commissioners on, and it's actually a very, very simple bill. It basically provides that in death penalty cases where, for whatever reason, the Office of the Capital Offender is unable to defend a qualified person, the presiding judge would appoint a maximum of 2 attorneys to serve as counsel, who would be paid from the funds of the Public Defender Standards Council at an hourly rate to be established by the council. It does allow but not mandate the county governing authority to provide additional compensation, and in the event that that's done, the presiding judge would have the discretion to appoint additional attorney or attorney, one additional attorney that would be paid with county funds at a rate that would be established by the presiding judge. I'm sorry, by the council. And that's essentially what it does. With your permission, Mr. Chairman, if I ask Ms. Haskins to address the bill first on behalf of the public defenders.
Thank you, Ms. Haskins, and I know you need to leave, so if you want to speak and then go.
Oh, I'm fine for about the next half hour,
right.
so I can definitely stay and answer questions. We've been working with Chairman Ralston on this bill. The reason that we proposed this bill is in conflict of interest cases, in capital defender cases, basically when the capital defender has a multiple defendant death penalty case, there generally is a conflict of interest. In those cases right now, when there's a conflict of interest, the capital defender cannot handle that case. So those cases are actually handled and the attorneys are appointed by the presiding judge on the case. There is a very high-profile case, which I won't name the name of, that we have right now, where we actually are paying for 4 attorneys that were appointed by the presiding judge at rates of up to $175 an hour. What this bill will do is actually limit what the council's responsibility for payment is to a maximum of 2 attorneys, which is the Supreme Court rule in Georgia is that you must have 2 attorneys handling capital cases, and it's also the American Bar Association guidelines. So we would pay for a maximum of 2 attorneys at the hourly rate set by the council, which right now we pay $95 an hour to attorneys handling death penalty cases. So what we're trying to do in the future is avoid having a situation where we're paying for more than 2 attorneys at the state's hourly rate, just basically because of the costs associated with having more attorneys than that at higher hourly rates. There's no way for us to control our costs.
Thank you. Mr. Kimbrough, you want to say something?
Just very briefly, I just wanted to say that the Association of County Commissioners is happy to be partners with everybody in doing this legislation, because in that same high-profile case, which we won't provide the name for.
It's like Voldemort, isn't it? You can't speak.
That's right. The presiding judge in that case has given orders that the county will pay for these additional attorneys at whatever rate he decides, and there is, again, no limitation. And even though, I'll give this background in order to try to keep my job, county commissioners are not happy about having to provide any funds in capital defense cases, because according to the original statute prior to this bill, all of the attorneys were supposed to be paid for out-of-state funds. But we understand that to the extent judges are going to do what they feel they must do in order to execute their duties, we would like to at least see some guidance in the law as to how far out they can get. We believe that this bill accomplishes that intent and provides some clear guidance, and we're happy with that language.
Usually the Superior Court judges and the county commissioners get along pretty good in most of our counties, don't they?
Absolutely. And we believe that to the extent that going forward, most presiding judges would probably follow the ABA and Supreme Court rules. We probably would never get to the 3rd attorney that the counties would have to pay for, and to the extent we did, the judge would be extremely sensitive to that issue.
All right. Are there any questions for either of these fine witnesses who testified here on behalf of the chairman's bill?
Sure.
All right, Mr. Seth.
I just have a simple clarifying question. The $95 an hour rate, are those typically folks that are brought on as employees of the council, or are those folks in private practice that you're paying?
Those are people in private practice. We actually have a capital defender office where we have full-time employees that handle death penalty cases. But when there's a conflict of interest, the capital defender office can only take one of the defendants, so the other defendants actually have to be handled by private attorneys, and the presiding judge appoints those lawyers. So we have to set an hourly rate for those cases, and that current hourly rate is $95 an hour.
Are you able to get attorneys of adequate stature that can work on these cases for a $95 an hour consulting fee?
We were paying $125 an hour, but we did reduce that hourly rate based on our budget and the need to pay a little bit less. But it's difficult, but we are able to find lawyers that will take the cases.
I mean, I asked the question. I work in consulting myself on the engineering side, and I just, you typically, for an attorney, I don't think I have to tell most folks in this room. I mean, you're talking people, attorneys coming out of school are billing substantially more than $95 an hour. If you're talking about somebody that could work on a high-profile case, I'd think we ought to be north of that considerably. I'm just asking the question because if we're not providing adequately for these cases, that just concerns me. But to that point, I'll assume the chairman has that figured out in his bill.
The chairman wants to respond to that.
I just wanted to thank you. it was a very kind comment that we should get more than that. The way it works, Representative Sensler, is I mean, historically, and I know, looking around the room, there's some attorneys I know have done these. I've done them for half or less than that over the years. I mean, I think there's a feeling that this is not, you know, at some point it ceases to be an economic decision and becomes part of what we feel obliged to give back to the community in the nature of helping serve the indigents in the court system.
Question. Mr. Knox.
Isn't it kind of like serving in the General Assembly?
Well,
it's not as voluntary.
Chairman Knox, I was thinking that if we drag on till April or May here, that $95 an hour sounded pretty good.
All right. Are there any other questions from any of the committee for any of the witnesses of the chairman? If not, I'll entertain a motion. Mr. Levitas, trying to get back in the good graces.
Let me second that.
All right, here we go.
We go.
Uh-oh. He's amending his own bill.
Yeah, I'm amending my own bill. Do we have a...
There's a motion and second, but we'll hold that. You got it.
All right, I'm going to propose, Mr. Chairman, two fairly minor amendments. The first is on line 20 of page 1, replacing the words presiding judge and inserting in lieu thereof the word counsel.
Okay, is there any objection to that amendment? There's no objection. That amendment is adopted.
Then on page 1, line 19, I'm sorry, line 18, let me write this out. After the word may, strike appoint additional attorneys and insert in lieu thereof may not appoint more than one attorney.
Okay. All right, is there any objection to that amendment? All right.
I'm sorry, one additional.
One additional.
Yeah, one additional. May not appoint more than one additional attorney.
All right, any objection to that amendment? There's no objections adopted. Seems like we have one.
Oh, yeah. Is this your copy?
I think that on line 19 you would strike or attorneys.
Yes.
Is that an amendment?
Yes.
Any objection? It's adopted.
Thank you, Mr. Chairman.
All right, I think we previously had a motion. That motion is now to pass the LC 292559 as amended. Is that correct?
Yes, Mr. Chairman.
Still second it?
Still second.
All right, any discussion? Hearing none, all those in favor, raise your right hand. Opposed, like sign. Bill passes.
Thank you, Mr. Kimbrough, and
Thank you.
tell her to have a good first birthday party.
Thank you so much.
Yep. All right. Call House Bill 415. Les, if you and Jennifer would come around, please. Thank you for your patience. The chair tries to accommodate birthday parties for one-year-olds when we can here.
Miss Ammons has a new child at home, actually.
Really?
She'll be 3 months old on Friday.
Oh, wow.
Okay.
Congratulations.
Thank you.
So we're not going to make you come back on Friday.
Thank you.
That's your first?
Yes, sir.
May I present the bill, Mr. Chairman?
Please recognize
This is a
Chairman Mumphrey.
substitute to House Bill 415. It's LC 341142S. This came through my subcommittee, and there has been some change to it, not a lot of change. But, the first part of the bill deals with various pieces of documentation required for persons to seek temporary licenses or identification cards. And it also, is this the one that provides that there's it only lasts a year?
That's correct. It's
if you don't have a visa or a some sort of documentation that shows a period longer than a year, then you would only get a license for 1 year. Is that right?
That's correct. It's lines 1 through 4 on page 2. Currently, there's some immigration documents that are issued by the Department of Homeland Security that don't contain an expiration date, and the expiration date that we would impose would be a 1-year limit, which is consistent with the time limit that's imposed for certain documents under federal law under similar circumstances.
The next section, Section 2, deals with driver's licenses, and it essentially, I am being told, does not make any change in the law that it's always said that our law has always been that we will honor a revocation or suspension of license from another state. There are states, for instance, New Jersey happens to be one that I know about, that might have a 10-year suspension of driver's license. If you move to Georgia from New Jersey and you're carrying a 10-year suspension of driver's license, you have to serve out the 10-year suspension of driver's license in the state of Georgia. This section is restating that fact, and it's also adding driving privileges, which is just a response, I think, to a case that instead of licenses, we're just calling it driving privileges to broaden the
valid Georgia driver's license, and potentially even going back to that state where they're suspended or revoked with that valid Georgia license.
Section 3 is pretty simple. It simply says that if you have multiple offenses while you're multiple driving offenses, such as, say, reckless driving and fleeing and eluding the police, that you would have a separate point, separate points for each of those offenses, even though they're theoretically part of the same transaction.
That's correct.
And that is not a change from what the policy has been and the way points have been assessed for many years.
That's correct. It's just clarifying so that it's clear that what we've been doing is the legislative intent of the statute.
Section 4, this is dealing with what is this? This is dealing with driver's license suspensions.
For teen drivers.
Right, for teen drivers. One thing I do want to point out about it is found at D1. It has been the law in the state for a number of years that if you have someone who is under an age that makes some difference, 18 or 21, especially 21, and you receive a ticket, for instance, for DUI, and you're under 21 at the time, but at the time you go to court, you're over 21, you don't suffer the suspension that you would suffer if you were under 21, and that is being preserved in this particular piece of legislation. No change. That's found at D1 at the bottom of 3, and bail me out here and tell them what all that other stuff is.
Paragraph B deals with clarifying, we hope, the penalty for teen drivers who are convicted of driving under the influence. The current statute provides that a first suspension under this code section is for 6 months, and a second suspension is for 12 months. But there's some confusion because for that first offense, if the teen's blood alcohol concentration is over a .08, he gets that 12-month license suspension on the first offense. And we've had some instances where the department's decision to impose a 12-month suspension for that second DUI for the teen driver, the 12-month suspension has been challenged by the attorneys for those children, because in instances where the blood alcohol concentration has been less than the .08, and it has been the department's interpretation of the statute that no matter what suspension is imposed under this code section, it's legislative intent that it should be for 12 months. And so we're hoping that by making this amendment, it becomes clear to everyone else reading it that any second suspension under this code section is for 12 months, no matter what the child's blood alcohol concentration was. The change in paragraph B1 is not a substantive change. It's just a language change to clarify that the administrative license suspension that the child gets can be counted towards the suspension imposed for the DUI conviction. The current language in the statute implies, at least to some attorneys who've challenged us on this, that the child ought to be able to get credit for the administrative license suspension towards any suspension imposed as a result of a conviction arising from the situation that caused the administrative license suspension. That's not the case for adults, and it has not been the department's interpretation that it should be different for teen drivers. And so we've taken the language that applies to adults and put it into this statute that applies to teen drivers, so that those over 21 and under 21 are treated exactly the same.
It also says in D2, which is at the top of page 4, that each offense for which a conviction was obtained shall be treated as a separate transaction. That for suspension, for opposing points, which of course means that you can collect multiple points on one transaction if there are multiple convictions arising out of it. I think that's clear. Section 5, notwithstanding any of the provisions of this chapter, the suspension imposed shall be in addition and run consecutively to any other suspension imposed by the department at the time of the conviction that results in said suspension. This is regarding running suspensions consecutively to one another.
Yes, sir. For drug offenses, federal law requires that states impose at least 6 months of a driver's license suspension for any drug conviction. And this actually was the law in Georgia prior to 2005. The department took it out, not realizing that it was required, or asked the legislature to take it out, not realizing that it was required by federal law, and now we've realized that we have to put it back in. So suspensions imposed for convictions for drug offenses would, again, run consecutive to any other suspension that's already in place. If the customer has never been licensed, then he or she would need to come in, make application to be licensed, and then the 6 months would start running.
However, interesting aside about this, I think you were explaining to me that if you have multiple drug offenses, that they don't run consecutive to one another if they are in the same transaction, unlike a traffic offense.
That's correct. Drug offenses, the appellate courts have held that if they arise from the same incident or are adjudicated on the same date, or the convictions are dated the same, that they are considered one transaction. The thought process behind that, according to the appellate courts, is that the suspension for a drug offense is intended to be punitive, unlike a suspension for driving misconduct. And because it's an enhanced penalty that does not necessarily have anything to do with driving a car, you need not even have been in a car, around a car. The offense may not have had anything to do with a car. The drug offenses are treated differently than suspensions for actual driving offenses.
Section 6 deals with identification cards, and I believe it makes their obtaining an identification card identical to getting a driver's license.
That's correct. Currently, identification cards are not subject to renewal. If your identification card expires or you lose it, you have to come in and make application for a new one. The time starts over. You have to pay the fee again. That's not customer friendly, and in our efforts to be faster, friendlier, and easier for our customers, we think it's a good direction to go to make identification cards identical to driver's licenses, in that they are subject to renewal, and that if they're lost, the customer can just obtain a replacement without having to pay the full fee and start the time period over again.
And Section 7 is directing the employment of 30 investigators. I think this was in the governor's budget last year.
It's actually from this year. It's his Secure ID initiative. Currently, the statute limits the number of investigators that we're allowed to employ, and this essentially doubles that number so that it encompasses the 10 that the governor would like for us to add for his Secure ID initiative.
And it would, of course, be subject to appropriation.
Of course.
That's, question.
Representative Sensler.
To the witness, you said that there's a federal requirement for drug convictions to lose a driver's license for 6 months?
Yes, sir. It's in the Code of Federal Regulations. It provides that all states must impose at least 6-month suspension. Georgia has enhanced penalties for multiple convictions, but it must run consecutive to any other suspension that's already in place. And if the customer has never been licensed, they need to make an application to be licensed, and then the time can start running.
So if someone were, say, a 23-year-old were convicted for possession of marijuana, for example, with that there'd be a 6-month suspension of their driver's license?
Yes, sir. That's already in the law. The change.
Actually, in Georgia, it's 12 months.
It's 6 months for the first one.
Oh, okay.
The suspension itself is already in the law in that code section. This essentially puts back in the consecutive language that we took out in 2005, not realizing that we were required to do it for federal law.
When did the federal law establish that as a requirement?
You'll bear with me for just 1 second.
When they gave us the highway money.
As always. And again, I asked the question, have we seen an issue with uninsured motorists when those suspensions of licenses always concern me, because operating an automobile tends to be a lifestyle issue, and if we're being required by the feds to suspend people's licenses for even relatively minor drug convictions, then I'm just asking to really understand where that came from and the history of that.
The suspension was added in federal fiscal year 1996.
Okay.
And so the General Assembly probably enacted it
about 10 years ago?
Year. Yes, sir.
Okay.
That.
Representative Bearden.
Can I ask a question about that issue?
Representative Bearden yields to Vice Chairman Mumford.
If you have a no load, you don't get the suspension, correct?
Yes, sir. There are a number of different ways that a defendant could avoid a license suspension for a drug conviction. There's the conditional discharge language in Code Section 16-13-2. There's first offender treatment, which the appellate courts held in the Priest case would relieve the defendant of the license suspension. So,
what about no load?
That's part of the conditional discharge language.
All right. Sorry, didn't mean to step on your toe.
Representative Bearden.
Section 1, Section 6. I'm sure you're familiar with the matriculate, I have a hard time saying that, consular card.
The matriculate consular? Yes, sir.
That's the word thing. That's a tongue twister for me on that one. In the state of Georgia, is there any way that card could be used for any type of official ID, license, or permit?
Not anything issued by the Department of Driver Services.
Okay, but I just want to make sure, because if it was, this would be a good one to attach to make sure it don't.
This code section was enacted in House Bill 577 in 2005. It went into effect last July, and it has set forth the circumstances dictating the temporary ID cards for folks who are not citizens. But the department has long since had a list of documents that were acceptable as proof of identity, and it has been the law in Georgia, I think, since at least 1995 that you have to be legally present in the United States. And the matriculate consular card, which you probably know, is not deemed by the department to be satisfactory proof, and really by our colleagues across the country. It's a document that's issued by the Mexican consulate usually, and there is virtually no effort made to verify the identity of the person, that they're even from Mexico, and we just don't think that that's adequate proof of identity.
I appreciate that, because it's getting more and more acceptance in certain areas, and we just want to make sure it doesn't on this one right here, so thank you so much.
Yes, sir.
Representative Lunsford.
Muchas gracias, senor. I do have a question for you, if I could, on page 2.
I was just going to say that the prime location is the DDS Customer Service Center in Villa Rica, where one can get these cards.
Villa Rica, that's why they go there.
All the cameras are turned on.
Page 2, line 24. I have a question for this. Have we not just created an arbitrary judgment made by the commissioner, who may or may not be a medical doctor, who may or may not be a physical therapist, or may not be a driving instructor, for him to make a determination whether a physical may or may not be fit?
This language that's subparagraph 6 of paragraph C is actually not new language. That's actually language that's in the existing statute. And there are two other statutes that deal with medical revocations of driver's licenses. It's 40-5-35 and 40-5-59. 35 deals with reports from physicians, and we have a medical advisory board who reviews those reports. The customer is entitled to a hearing if they believe that the doctors that we have had look at the documentation are incorrect, so that an administrative law judge at the Office of State Administrative Hearings would have an opportunity to review both the customer's documentation and the documentation that we've gotten from our experts. And then in 40-5-59, that's instances where we get reports from other people. That provides for reports from law enforcement officers. If a judge directs the department to inquire into the medical fitness of a customer, or if for some reason we just have reason to know that a customer is incompetent. We have a customer who comes in and is physically unable to operate a motor vehicle for some reason. They can't pass the vision test, or some other physical impediment that they may have. It provides for a procedure by which we can inquire into that person's medical fitness. They're given the opportunity to take the forms that we've created to their physician, have their physician look at the requirements that are set forth in our regulations and established by our board. So the short answer to your question is no, our commissioner is not making arbitrary decisions about that. There are doctors involved. There's an entire procedure set forth. Their due process rights. And it's existing law. That's not a change.
No, I never questioned whether it was a change or not. I was just thinking that because it says who the commissioner has good cause to believe. It doesn't say who the procedure or who the medical doctor or who about. It says the commissioner makes that call.
And that's, but yes, sir. And it's essentially relying on those other statutes for making that determination.
One more question, Chair, if I can follow up. Under Section 7, I just have real heartburn. Excuse me, I'm sorry, page 2, subsection 7, starting line 26. And I'm wide open for members of this committee to correct me if I'm wrong, but I just have a real problem. I consider the state of Georgia to be the ultimate authority of the law for the state of Georgia. Just my personal opinion. But when we're going to invoke the punishment or revocation of a driver's license based on another state or commonwealth's laws, whether we agree with those laws, maybe the punishments there are harsher than ours. Like New Jersey has lifetime loss of your license. I just have a real problem continuing to codify that we're going to honor some other state's law because we don't know what that law's going to be tomorrow. Tomorrow they could say a teenage driver at 17 years of age is doing 30 miles over speed and loses his license for 20 years. And if that's the case, we just codified it and said we're going to do it in Georgia. Am I wrong?
No, sir, you're not wrong. If that's what some state decides to do, then the department would honor that suspension. Essentially what this is doing is not changing what operationally we've been doing since this code section was enacted.
Maybe it's wrong, though.
And that's something that may bear further conversation. Essentially what my role is, the general counsel is to identify the legal issues, and this has been a legal issue that's been litigated. And so the reason that we asked the sponsor to put this language into this bill was to address an issue where we thought we had incorrectly interpreted the legislative intent of the statute. We'd been challenged on that. We had the Roberts decision that said, because of the way that the statute is worded, no, the department wasn't right. And so to make the law match what we thought was the legislative intent, we've gone back and added this language, or asked you to add this language back in. If it's not the legislative intent, then obviously that would need to be changed.
Thank you, Mr.
Any other questions? Further questions? Further questions? You wish to be recognized?
Well, I'd like to offer an amendment, Mr. Chairman, but I'd like to use Ms. Travis' wordsmith and Ms. Abrams'
So
John.
you want to tell her what you want to do and have her put it into words?
Yes, sir. What I'd like to do is on page 2, starting line 7, and we're all fine with that, and after that, Jill, what I'd like to somehow say is provided that punishment in the alternate jurisdiction is no more severe than it is here in Georgia, so that Georgia's laws prevail, so that we don't have some crazy legislator like us in some other state that changed the laws that we have to honor. And I don't know exactly, Mr. Chairman, defer to your omnipotent wisdom, sir, to help me wordsmith that if this committee so desires.
That's going to be a little tough to put into words, because I'm not sure what the criteria would be by which you could quantify that. I mean, Representative Cecil?
Could we have something that we would honor that up to a period of, say, 3 years or 2 years or some amount of time certain that, you know, anything that was lifetime or 20 years or 2 years would all be treated as 2 years? But after 2 years in this state of the suspension, you'd be up and running.
Vice Chairman Mumford.
What's the longest period of revocation that we have, or I guess revocation of a license that we have?
Under Georgia law?
Right.
I'm going to have to give you kind of a lawyerish answer.
Mm-hmm.
5 years for any revocation or suspension that has a set period of time.
Right.
There are some that...
well, some of these, like if you're mentally defective or something like that.
Well, and I'm talking about non-commercial drivers. With your commercial drivers, they could lose their commercial driving privilege for life. So the commercial drivers, the answer is life.
Mm-hmm.
The non-commercial drivers, it's 5 years.
Now, does this section affect commercial drivers as well as regular drivers?
The department would recognize a commercial disqualification imposed by another state, partially because of this code section, but also because of the applicable language in further back in Chapter 5 of Title 40, and because of the applicable federal regulations where there's language elsewhere that says if there's a commercial disqualification imposed by another jurisdiction, we would not be able to give that person a commercial driver's license.
That help you out?
Yes, sir, I'm still a little confused, but I'm used to living that way in most cases. But I have concerns, and one of them is we have a harsher penalty in another state. Or when we look at someone like California who use things through tinted glasses. And for instance, if they charge, for instance, in Georgia, we've got our second, third, fifth DUI, and you know what your punishment is. If that got watered down in California, would you honor that suspension in California for the same period of time California had? Or would you impose Georgia's penalty on it when they came here?
If they were
Lesser than us.
if we're talking, so that I understand what you're asking me, you're talking about a California resident who was convicted in California. We would honor what California says.
So, in other words, the DUI in there, if they only suspended, say, 6 months, this is hypothetical, where ours is greater than that, if it was suspended, the conviction was served in the other state, you would honor their conviction rather than our state law.
Only if it's a California resident who committed the offense in California and then moved to Georgia. Totally different scenario if you're talking about a Georgia resident who gets convicted in California or a California resident who gets convicted in Georgia.
Could you expound on that? If it was a Georgia resident convicted in California for the same offense?
They would get both the Georgia penalty and the California penalty. And the same thing for the California resident who gets the ticket in Georgia. They would get the California penalty and the Georgia penalty. The only,
sure. Of course, I haven't had a ticket here, so.
The only folks that this code section deals with are people who live away, have a problem away, and then come to Georgia.
Let me, man.
Yeah, Vice Chairman Mumford.
If you're helping me.
Now, if you go to California, and I've got a Georgia driver's license, I'm driving in California, I get a DUI. You get notified that I got convicted of first offense DUI in California. I don't know what their rules are, but you're gonna mess with my license like I've got a first offense DUI in Georgia as soon as you get notified, right? And I got to go do all the stuff in Georgia. Now, did I understand you to say that then you're going to somehow, if California has a further penalty, you're going to impose that on me?
California's going to impose it on you.
Well, they're not going to impose it on my California driver's license because I ain't got one.
They're going to impose it on your California driving privilege.
Yeah.
So that if you were to try and drive in California, or if you were to try and get a driver's license in California, whatever rule applies there would apply to you while you were there.
So that's where this driving privilege language is coming in this section too?
Yes.
Representative Lunsford.
Yeah, I have a question. So, for instance, if Chairman Mumford got a DUI in California, heaven forbid, I know he would.
Because I can't afford the airfare.
Exactly, not on our legislative salary. However, for instance, he was there, he was arrested, California law says you pay whatever it is, $600 first offense fine, serve 3 days in jail, go home, and you lose your license for 6 months. Then when you got notified, he would have to come to court in Georgia?
No, sir, he wouldn't have to come to court, but his driver's license would be suspended.
But
And
not the Georgian one that you're suspended.
That's correct.
Is that not double jeopardy?
No, sir, it's not. Driver's license suspension is not considered a criminal penalty. It's driving is a civil privilege, so double jeopardy does not apply.
No, but I mean mentally.
To the customer who's enduring both penalties, yes, it could be, but it goes back to your question. We can't prevent California from imposing their penalty, but don't you want that Georgia resident to be subject to the Georgia penalty?
I don't know if I want to subject to
What?
That's Chairman Mumford.
because California could be higher. I'm sorry. I mean, what if theirs was 5
So,
and ours was 2?
Even though I've got a Georgia driver's license and, I go to the DUI school, I can get a work permit, do the 120 days. If California law says for first offense, I don't know what it says, but for first offense DUI, I got a 12-month suspension driver's license. I do all of that stuff, and it makes not the slightest difference to the DMV that I had a Georgia driver's license and I'm being subjected to the Georgia penalty. I've got to do the foreign jurisdiction's penalty in addition to the Georgia penalty.
Correct.
And she keeps a straight face when she says it. She's good.
Do you have your hand up, Representative Byrd?
I do, but it has nothing to do with what y'all were discussing now. So if it's Chairman Knox and Representative Bearden to deal with this, I have a different question.
All right, I think the hands sort of went up at the same time. Chairman Knox, then Representative Setzler, then Representative Bearden.
This is currently the law is that you can't suspend if somebody comes driving through Georgia on a Tennessee license. We can't suspend their Tennessee license, correct?
Not exactly.
They committed an offense in Georgia. They're driving on a Tennessee license. They're a resident of Tennessee. We don't have any authority to suspend their license in Georgia, do we?
We would suspend their Georgia non-resident driving privilege if it was an offense for which Georgia mandates a suspension. Okay. We would report the conviction to Tennessee, and Tennessee would take whatever action they deem appropriate, which could be nothing, but it could be more or less than what Georgia's doing as well.
I'm just wondering how this is, but we're going to change that now with this, aren't we? Where we're going to allow both these penalties to be imposed?
That's already the law. This bill would have no impact on this scenario that we're talking about whatsoever.
Except to clarify, correct?
No, sir. The customer who comes to Georgia or goes to California and commits an offense, this has nothing to do with that. All this has to do with is somebody coming from somewhere else and trying to get a Georgia driver's license. If you're suspended or revoked wherever you're coming from or somewhere else, let's say it's an Alabama resident who has a suspension from Florida, we're not going to give them a driver's license. And that's already operationally the way that we're working. We're just trying to close up the language that the court identified in the Roberts case as being a gap. But the scenario that Chairman Knox has described and that Representative Lunsford has described, where it's a Georgia resident that gets DUI in California or a California resident who gets a DUI in Georgia, this bill does nothing about that at all. It's not even mentioned. Those are different code sections.
Representative Setzler. I'm sorry? Okay. Representative Beard.
Forget my question.
I've got a question.
Representative Mumford.
Could you describe the fact pattern in the Roberts case for me?
In the Roberts case, it was a Georgia resident who had some Georgia convictions for DUI. He moved to Florida and got some more convictions for DUI. Based upon the Florida and Georgia convictions, while he was living in Florida, Florida revoked for life his driving privilege in the state of Florida. The customer then moved back to Georgia, obtained a Georgia driver's license. Georgia was not aware at that time of the lifetime revocation of his driver's license in the state of Florida, and so we issued him a license. When we became aware of the revocation in Florida, we canceled his driver's license, and he appealed that to the Superior Court, and then that was appealed to the Court of Appeals, and the Court of Appeals held that 40-5-22 says if your driver's license issued to you by another state is suspended or revoked, you are not eligible for a Georgia driver's license. So even if we were to leave the code section alone and take this section out of the bill, that's going to stay the law in Georgia if we don't make other changes.
But this section's going further than the Roberts decision because it's really saying that lifetime suspension would apply to this fellow, even though Georgia doesn't have anything like a lifetime suspension or anything that's even remotely similar to a lifetime suspension.
What this amendment does is it says that if Mr. Roberts had an Alabama lifetime revocation, which technically doesn't exist, but we'll ignore that. If he had a lifetime Alabama revocation, but he was licensed in Florida and moved to Georgia, we still wouldn't give him a driver's license, which was what the department believed was the legislative intent, which may have changed.
Give me that again. If he had an Alabama driver's license, moved to Florida.
No, sir. He had an Alabama driver's license and got enough DUIs in Florida that Florida imposed a lifetime revocation, and then he decides to move to Georgia. Georgia would not give him a driver's license because of that Florida revocation.
Representative Sessler.
And Representative Lunsford may be the puncher. I'd like to, unless the council gets back in, ask how we would draft language that would achieve following public policy goal. And that would be to say that we would revoke a license up to a maximum period of 5 years or any, we would match another state's revocation. Someone removed from that state into Georgia, we would match that period. Even if that period were more stringent than our period was for the same offense, up to a maximum of 5 years, but we wouldn't prevent someone in Georgia from getting a license for more than 5 years if the other state's penalty was more than i.e., if someone came in from Florida and Florida had revoked their driver's license, not CDL, but a regular driver's license, for life, for 2 or some odd 4, 2, 3, 4 DUI offenses, we wouldn't issue them a driver's license for 5 years, but after 5 years they would be eligible to submit for a driver's license. That's what I would like to draft up as a particular.
Did y'all have something to say? Okay, Representative Byrd, you want to ask your question?
I do, but now I want to make a comment. Why would we want to give somebody who has had major DUIs in some other state and then come to the state of Georgia and drive?
Again, we're not looking
to incentivize bad actors to come to our state. I think to Representative Lunsford's concern, I'd like to treat them in the state the same way we would have treated them had they been Georgia citizens. And if 2, 3, 4, whatever number of DUIs they got in another state, I think we ought to treat them just as if they had gotten those in Georgia. Now, if Georgia decides in its wisdom that needs to be a lifetime revocation, then perhaps we ought to recognize that. But what I'm hearing from the council is, with the exception of CDL drivers, there's nothing beyond a 5-year revocation that we would issue in Georgia, and I would want to be consistent with that and folks moving from other states. That's.
Thank you very much, Representative Sessler. Did that? Did you have a?
Now, and actually, my other question outside of all of that, in section 7 on page 5. Is this new language about the commissioners shall have the authority to appoint and employ 30 investigators? Is this something new?
The number is new. The investigators are not new. We've had investigators since we were created. They conduct investigations into the presentation of fraudulent documents by our customers. If any of our employees commit a fraudulent act, they would investigate those cases and have made numerous arrests.
So we're asking for a 30 additional?
It would be going from 15 to 30.
And what's the fiscal note on this?
It's part of the Governor's Secure ID initiative and is already incorporated in the budget recommendation.
Thank you.
Further questions? Any further questions? Comments? It's a pleasure of the committee. Representative Bearden?
think there's Mr. Chairman, I think there's still a lot of questions that need to be answered, and I think we'll get some of those answers before the next meeting, and I would make a motion to table this for right now.
I know we all have a lot of work over that period of time, but I would like to ask Vice Chairman Mumford and Representative Lunsford and Representative Setzler, if they would, to meet with Mr. Hammond and Ms. Ammons sometime between now and that meeting, and see if y'all can resolve some of these concerns.
Mr. Chairman, can I tell you something? Since Miss Ammons is down in Conyers, I want to welcome y'all all to Conyers sometime later in the morning.
I think that's a good idea.
You have my permission to convene that little study group off campus. Representative Lunsford.
Mr. Chairman, I was curious, since Mr. Mumford's office is on Main Street in Conyers, maybe we use his conference room. It might facilitate this much easier.
I don't think it's suitable.
I would never be so bold as to invite someone into Mr. Mumford's office or his home. All right, have a motion to table this bill until next week, with the understanding that further work will be done. Is there any objection? Hearing none, it is. And I look forward to y'all's continued good work on that.
Thank you.
We have one final bill.
Too fast.
Are you going to have some?
No, I'm here.
Okay. I'm going to call. No, we have one.
Right.
House Bill 571. I turn the gavel over to Vice Chairman Mumford.
All right, House Bill 571 deals with 911 calls, family violence, to add 911 calls as a ground for a temporary protective, or the interruption of a 911 call as a ground for a temporary protective order. Call on Chairman Ralston to present the bill.
Thank you very much, Mr. Chairman. I'm actually carrying this bill for Representative Pam Stevenson. I signed on the bill with her, and all this bill does is simply add another ground for obtaining a temporary protective order. Already in Georgia law, it is a criminal offense to interfere with or obstruct. Is it interfere and hinder, Jill? A 911 call. That's a separate criminal offense.
Right, yeah.
However, the code section dealing with temporary protective orders, although enumerating every other specific ground of what could constitute in our criminal law domestic violence, does not include that as the basis for issuing a TPO. Ms. Stevenson shared with me her experience in failing to obtain TPOs when that was the basis, and after discussions with some judges that she knew, she brought the bill. I was happy to sign it, and that's very simply what it does.
Are there any questions for the chairman from anybody in the committee? There is a motion being made, Mr. Bearden. Oh, I'm sorry. You have a question?
No.
Yeah, motion. You make a motion. What's your motion?
Make a motion the bill do pass.
Second.
Yes.
All right. All those in favor, raise your right hand. All those opposed. Everybody else say goodbye.
Thank you very much. I don't have any further housekeeping. Stay tuned tomorrow, and we'll get you a schedule for what will probably be a busy week next week.